privilege to welcome you all here today. I must admit to have been a little bit ambushed. I was asked to introduce, to welcome you to this function, and I didn't know the background to this, that there's a long history to this of Nedbank's involvement in trying to get a forum going where council can meet attorneys and we can start the transformation, or we can enhance the transformation of briefing patterns at the bar. So it's very interesting to hear about this, and that it's been going on for more than just this year. So I'm very pleased to be welcoming you to this event. I think it's a very important event. I was just saying to the lead from Nedbank that it's amazing when you go to law school, they don't tell you that one of the things that you're going to do for a large part of your career is teach. And I think that this kind of event is very important, both from a teaching perspective and also from the networking perspective. So it's my privilege to welcome the panel as well, Amor Burger-Smith from Worksmans, Stephen Powell from ENS, Ofense Teledi from Nedbank, and Loiso Bavuma and Marlies van der Westhuizen from Fifth-Decker Hoffman. Without further ado, I will hand over to Marlies.
Thank you very much, Tim, for a warm welcome. I want to echo Tim's sentiments. What a privilege to have you here this afternoon. I hope the discussion is informative, that you all learned something from an extremely achieved panel. I certainly hope we can mingle afterwards, get to exchange virtual business cards and chat. I think I want to start off with a media alert the FIC issued, the Financial Intelligence Centre issued yesterday as it applies to designated non-financial businesses and professions. Welcome. The notice basically deals with the failure of these DNFBPs to file their risk and compliance returns. And there were 2 dates set by the FIC. So they say it's a direct contravention of Directives 6 and 7 issued by the FIC. And they use very strong language, such as that the failure by these businesses to not file RCRs is willful non-compliance, and that we're deliberately sabotaging the FIC's endeavours to get us off the grey listing. So our conversation is going to cover what the Financial Action Task Force is, what its structure is, what its purpose is. Stephen, you referred to the 40 recommendations as something else earlier in our informal chat.
We're not supposed to go there, but it was 40 shades of grey, but we've been compliant with quite a number of the recommendations. So there's been a lot of legislation, and the big challenge at the moment is to demonstrate that we enforce these new laws that have been promulgated. But part of today will be explaining some of these new laws as well.
We also will cover what the grey listing is all about, how we got on, what the chances are that we're going to get off the grey listing this time next year, what the Financial Action Task Force's 8-step plan is, as recommended to get us off the grey listing, measures already taken by the FIC to try and strengthen our anti-money laundering control and terrorist financing and proliferation of that financing. We're going to deal with some state capture recommendations, and then recent amendments to FICA to bring us in line with the global expectations of where we should be. Finally, we'll briefly chat about the responsibility of accountable institutions, what they are, and then we'll have a question and answer session. Even if we have to cut into our cocktail time, we will give you time to ask questions, and there are no silly questions. the topic might be new to some of you. So be curious and ask questions. We will take them as a panel and try and give you the most comprehensive answer that we can without taking too much time off our cocktail time. Without further ado, Loiso, please, can you cover what the Financial Action Task Force is, what its strategy is, what its purpose is, and what its structure is?
Good afternoon, everyone. My name is Loiso Bavuma. I'm an associate at CDH in the dispute resolution practice. I'm also part of the FICA advisory team. So what is FATF? The Financial Action Task Force. Okay. It's an independent intergovernmental body that was founded in 1989 by the G7 countries. And its mandate is to develop policy and to set international standards relating to combating money laundering, terrorist financing, and the financing of the proliferation of weapons of mass destruction. Since 1990, FATF has grown to about 39 members, including several observer organizations such as the IMF. These 39 members account for 90% of the global GDP. South Africa joined FATF in 2003, and if I'm not mistaken, is the only African country to be a full member of FATF. It's important to note that FATF itself cannot impose any economic sanctions, and so that isn't what the grey listing is. And their role is to, as I said, implement measures and set policies around anti-money laundering and counter-terrorist financing. So there are also several FATF regional style bodies, and there are a few African countries that are members of this. One is the East and South Africa Anti-Money Laundering Group, and another is the Middle East and North Africa Financial Action Task Force. Now, these regional style bodies obviously help promote measures relating to anti-money laundering and counter-terrorist financing in their respective regions. And through these bodies, there are 200 jurisdictions that are committed to complying with FATF's recommendations, which we'll touch on. One of the key tools of FATF is these recommendations, which they have creatively named FATF's recommendations. And there are 40 of these, and these recommendations essentially provide the framework for how to go about compliance with anti-money laundering, or money laundering and terrorist financing.
Thank you, Louis. So you mentioned that we became a member country of FATF around 2003. I think we were the 32nd member country. But just taking it back to the legislation that we had to implement to become a member country, and it's a little bit of what we're doing now, is we want to become off the grey list. The legislation was the Prevention of Organised Crime Act of 1989, and then the Financial Intelligence Centre Act of 2001. Both those pieces of legislation, in fact, few people know this, but were drafted together and ultimately pretty much rushed through Parliament, so that with our integration back into the international community, we could start trading more freely and create economic stimulus for the country because of the implementation of those two pieces of legislation. But everyone's panicked about grey listing and have been for what, 2 years now?
Yeah, this ugly G word.
Yeah, the ugly G word.
Words that we're not supposed to use. The G word is now the biggest ugly one that we need to deal with. Yeah, and we think about the grey listing problem. It's tentacles in so many areas of what we do and how we engage. And the grey listing came about due to the action group looking at South Africa, and we've got a problem with, if we think illicit funds flow if we think about drug trafficking, if we think about cyber fraud, these are all real issues that we as a country have to deal with. You know, if you think about, you know, the drug trafficking, that always links to inevitably prostitution, and it links to child pornography. So what is happening globally is so important. And if we think about, you know, what is this grey listing aspect thing that we're dealing with? In terms of grey listing, for country to be identified, to be placed on the grey list, the task force actually considers what they deem serious deficiencies within a government structure in a country. And where they identify concerns around money laundering is always one of the first things that get mentioned. And I think it's a massive issue. Later on, when we discuss, we get to accountable institutions and reporting, and you know, this morning's News 24, if we think about cryptocurrencies and the reporting expected around that, all those avenues open the door for something like money laundering. But then it's been reported on so many occasions also that South Africa is involved or allegedly involved in terrorist financing. That's one of the core focus areas of this task group, to consider whether they ought to then identify a country to be listed on the grey list. Just want to interrupt myself here and say one thing. It's not as if you wake up as a country and a government one good morning and now you're grey listed. There's a whole process that gets followed, and actually a very detailed process. And we as a country in South Africa in 2021 were given the opportunity to rectify misalignment with the global structures when it comes to money laundering and financing of terrorism. And in light of the fact that we missed that opportunity to rectify it, that eventually resulted in us being grey listed. So besides the fact that, you know, the task force will look at these serious deficiencies, they've set the minimum standards in the 40 recommendations, 40 shades of recommendations that put forward. And they assess both on a technical level. So we were assessed on a technical level, and I'll tell you a bit more about that now, as well as an effectiveness level. So let me start on the effectiveness level. And that's why, you know, I actually started as a criminal lawyer. And don't ask me why. I wanted to be a human rights lawyer, then realized I'm going to be poor forever. Then now I'm a regulatory lawyer. So I've had a very colourful career to date. But if we think about it from a effectiveness perspective, that's the whole emphasis we've got on why the National Prosecuting Authority is so important. Why the lack of skills they experience is such a huge problem. Why we want them to work closely with the hawks and actually bring about what we had many years back. We had an Office for Serious Economic Offences in South Africa. Stephen would know about that. And they were actually very good. They were very efficient in what they did. And they prosecuted what we now want the hawks to prosecute and the NPA's inability to prosecute. But they evaluate the effectiveness of these institutions. So if we think about effectiveness in what the task force looked at South Africa to determine whether we ought to be grey listed, they looked at the effectiveness of institutions. And so it's not a tick box list, it's actually more an assessment of the efficiency. But more so, they look at a country and evaluate a country on a technical basis as well. You know, what institutions have you implemented? What laws have you implemented? What procedures have you implemented? So we're making progress, and we'll discuss it later on. We've made great progress to move along in implementing laws, and we're making progress in strengthening institutions. And I think over the last 18 months, we've made great progress and there are new initiatives in place. But these are the aspects that this committee that evaluates a country will take into place to say, should you be as a country be grey listed? And I think, like Louisa said, it is not a sanction. Once you grey listed, the intent of the Financial Action Task Force is actually to work with the country to rectify, can we call it the fault lines that are in place. How do we assist you as part of a global economy to secure that you, and we'll speak about what the detrimental effects of being grey listed, but how do we actually prevent you becoming a negative energy and influence within a global economy where we want to create wealth globally for all citizens? And post an investigation like this, what the task force actually does, this is a mutual evaluation process that members, some of these 38 members come together and they then evaluate the process. And they formulate recommendations. We'll speak about the recommendations, which I think were very crisp, that they put forward in relation to South Africa. Our little problem now is that we've got till January 2025 to actually realign ourselves.
Thank you so much, Amor. That's very insightful. And one can look at the actions taken by the FIC in recent times. Sanctions imposed on motor vehicle dealers in the high value goods category, and think to yourself, also with reference to the media release of yesterday, that the FIC has just been vindictive. It's come down so hard on industry, on all accountable institutions. But South Africans, speaking very generally, have a mentality that what is not forbidden is permitted. And so you really have to control the journey that the FIC wants to take South Africa on to ensure that we can participate in international commerce. Ofensi, how did it come about that we were placed on the grey list?
Yeah, I think Amor covered majority of how we ended up there. But when you look at the 40 recommendations from a technical perspective, during the assessment process, South Africa was found to be largely non-compliant with about 50 of those recommendations. So that was a very, very bleak picture that was painted. Look, even from a technical perspective, your regulatory framework does not meet the requirements. 50 out of the 40 recommendations were largely either non-compliant or largely non-compliant. Although we know our pass rate in South Africa is 33%, but that was still below par. And when we even look at from an effectiveness perspective, South Africa was going through a state of state capture, featured a lot in the key findings of the recommendations. Because when FATF walked in here, they expected that from actions being taken, we needed to demonstrate that there was sufficient other asset forfeiture, or there was sufficient actions being taken against these criminals, and we were found to be wanting. And the other part, although the banks or larger financial institutions were found to understand their money laundering risk, from a terrorist financing perspective, it was a gap that was glaring across for South Africa. So a lot of issues were raised, even with the DNF PPs, where they said, look, you guys are not even registered, number one.
Yeah.
You don't have a risk management plans. Some of them don't even know what AML is about and what their responsibilities were. So that didn't paint a good picture for us. And that's how we found ourselves to be there. And South Africa needed to take quite drastic actions at the time to demonstrate that we can get out of this.
Stephen?
If I can just add on to that, I think we scored an own goal to a large extent. The Zondo Commission was incredibly valuable, and I given evidence at the commission detailing bribes that we identified in a number of our investigations. And some of these matters are going forward to prosecution. So I'm going to be witness number one for the state against a number of prominent politicians. So I think a few years back, we bought Kevlar vests when we did some of the asset forfeiture stuff, because we were seizing assets of drug dealers, and we realized that actually our risk management needs some reworking, because we were going to drug dealers' homes armed with pens and writing pads and taking away their sports cars and freezing their bank accounts. And so we've shelved the Kevlar jackets because the asset forfeiture went very quiet during the state capture years. But I think what Betsy alluded to is a problem. We're not seeing prosecutions emanating from the evidence that was palpable and clear, and a lot of individuals were implicated with direct evidence, and we needed to demonstrate enforcement. We saw a lot of legislative activity late in 2022, but it was literally in the months building up to Feb 23 when we were grey listed. And the FATF response was too little, too late. We can see you've passed new laws, and on a technical evaluation, you are complying with some of what we've requested, but there is insufficient time to demonstrate that these new laws are effective. And come January next year, if we don't have prosecutions, we're going to have the same criticism from FATF. I'm always optimistic. And actually, I started my career, I did my capita selecti with medical malpractice. And after studying that, I thought, I'm not interested in suing doctors. And then I ended up becoming a prosecutor and putting bad guys in jail. And that's what I've continued to do. So I do the forensics practice coupled to regulatory compliance. And so we in the coalface, and we often helping the FIC with reports that we issue, and we help our clients when they're deficient in terms of timelines for reporting. But the point around terrorism is the FATF said to us, South Africa as a country, we know from your profile there are terrorist cells active in your country, but you've had one prosecution in 30 years. It's just not good enough. So we need to up the ante on that. We need major improvements to proliferation financing. And then the other areas are the gold and diamond dealers. You've seen in the press, there's been a lot of activity on those sectors at the moment. And our banks and financial institutions are mature when it comes to money laundering, but there are a whole lot of other bodies that are regarded as non-compliant. And the FATF didn't mince their words in we call it the MER report, the Mutual Evaluation Report. If you haven't read it, it's on the internet. It makes for interesting reading. And they highlight that lawyers are gatekeepers to corruption. And they are not the large law firms, and none of the firms here. There are lawyers who allow their trust accounts to be abused by clients for money laundering. And those things need to be stopped. So we need to educate the sectors. And the activities of the FIC, what the FIC is trying to demonstrate, and they might be becoming too aggressive and too assertive, is one of the criticisms by the FATF was that there's not enough supervision by regulatory bodies. So the FIC has taken over the responsibility from the Legal Practices Council to regulate law firms. And it's a lot of the smaller guys don't have the resources to have a compliance officer. They don't have the resources to go and develop a risk management compliance program. So we are struggling, and I think some wake up is necessary. And then estate agents are problematic in many areas.
And
I'll stop now. But the one thing that I used to do when I did these asset forfeiture is, and we would go to the properties of these drug dealers, they would be land barons. They would own 4 or 5 properties, fly overseas all the time. The problem is someone was banking them, and an estate agent was doing the conveyancing, and the reporting obligations just weren't adhered to. And those are the things that we need to address.
And the lawyers were doing the transfers of the properties.
Yeah.
So I think what we've done is sketch a broad legislative background to where we are today. And very importantly, looking at that background, when FICA was first introduced, we moved from a tick box exercise for compliance. I've asked this question, I've got this document, to an entirely risk-based approach. And talking about educating sectors, one of the recent amendments to FICA was that dealers in precious stones precious dealers in stones and precious metals are also now accountable institutions. There are many of the mining companies that haven't even thought about this. They're blissfully unaware of their obligations. What are the practical consequences for South Africa of being grey listed?
We all spoke about that in the period of fear that we are going to be grey listed. And the first instinct immediately in commentary centered around the fact that grey listing has got a consequence for the financial health of a country. Whether we want to know it or not, that is a reality. So our economy and our financial system suffers. And it suffers because we it makes it more difficult for government to obtain loans and funding. We know we need that as an economy where we find ourselves, and we need to borrow money on the international markets. And not only that, it's got an impact on foreign direct investment. And I tried to do some research so I could present some statistics. And I just want to give you a couple of views. And this was an IMF report at the end of 2021. I'm going to just give you this background and then make another comment, which I believe is actually valid for our economy. But the study done by the IMF, and they used machine learning to actually analyze the data at their disposal, saw a significant effect of grey listing on capital inflows. If we think about capital inflows, they reported an average of 7.6% of GDP decline in a country's capital inflow if the country is grey listed. So a major problem for us. If we think about direct investment inflows, that the data demonstrated a 3% average decline on foreign direct investment. Portfolio inflows declined on average by 2.9%. And then investment inflows overall declining by 3.6%. So this is a direct correlation to what we see happening on a macroeconomic level in an economy on the back of grey listing. At the same time, we need to realize that whomever we engage with in the global economy has now got a higher transaction cost when they deal with us as a country, because they've got higher due diligence obligations that they need to comply with. Indeed. And it also impacts each business, as we've just discussed, lawyers and estate agents. I think there are other entities that the FIC should maybe consider a bit more closely as well. But at any event, suddenly you've got more, your OPEX increases because you've got these additional compliance obligations. And I always look with great sympathy to the financial services sector and also the telco sector, because they've got very strict compliance obligations, and especially the financial services sector. We as a country seem to have adopted an approach that we want the financial services sector and the telco sector to sort out all our problems, and we don't want to worry about anything, not realizing each of us carry a responsibility for the financial health. Now, I know that the research and the IMF research demonstrates the impact on the economy and on a macroeconomic and a financial system level as following grey listing. But I want to make the following comment. If we see a decline, and we do see a decline in our economy, we can't blame all of it on grey listing, because through a period difficulty we've moved through as a country, we already saw a decline in foreign direct investment. We already saw a decline in capital inflow. So I think if we want to evaluate South Africa, I think those statistics are a bit out of line. But that demonstrates the direct impact of grey listing on an economy.
And just to add on more what she said, I mean, the other consequence that we don't necessarily think about is the rush that is normally followed in terms of the legislative framework. So we've seen it in a number of countries where after they've been grey listed, what will normally happen is that there will be a period where we now try to enhance our legislative framework. But that is not done in a prudent or well thought out manner, where all these legislations are now being put in place, but they're not well thought through. And we've seen that also play in our space, where some of the proposed updates to the legislation, practically speaking, they will have negative consequences, especially for financial institutions where there is a greater burden of compliance. And some of the guidances that is coming out, like the recent one on beneficial ownership, it's starting to make it's not practical. It does not make sense. But we're rushing through this because we want to get off the grey list. But those are the consequences that we never think about. Is that no, it's only financial, but there's other ones like the legislative framework that's now we're feeling it's just going through a tick box approach. We want to adopt a risk-based approach, but now we're going back to a risk.
See, sorry, may I just say the following as well? You can need to link to that. You can never look at any piece of legislation in isolation. And that is exactly the point where we are now seeing misalignment creeping in. It's a knee-jerk reaction, and where we've got the opportunity, and maybe if Parliament can just please move a bit quicker in their processes, but if you look at the amendment of a piece of legislation, we know as practicing regulatory lawyers where there are potential problems with a piece of legislation. So while you're doing it, take a holistic approach and address the legislation in totality and its linkages with other regulatory areas, and not just amend 2 or 3 sections. I had a discussion, and I mentioned it the other day when we were talking about this afternoon with our previous Deputy Minister of Justice and Constitutional Development, because I criticised what came out of Parliament. I thought they had a knee-jerk reaction and they missed various opportunities to address the realignment of the legislation. And he said exactly that. Grey listing is such a problem. They're trying to fix the tick boxes as quickly as possible, not realizing what other problems they actually create. Because if you're supposed to be compliant and you are confronted, remember, if you don't comply with while you're grey listed, there's where it actually then comes to is when you blacklist. And if you're there in the blacklist, on the blacklist, then sanctions apply. So we can't get onto the phase where we don't meet the deadline. So I understand where government wants to move, but we still need to think about it holistically. We've got such brilliant people and brilliant legal minds in the country to assist, and they ought to form a bigger group of task teams to actually address the issues.
I mean, I think that we're seeing a repeat of what happened in the late 90s and early 2000s, where there's a rush to become a FATF member country. We did well in the first 2 mutual evaluations, and then we get told you need to implement the following steps to get off the grey list. And there is a rushed approach. I mean, just to mention one aspect, it's the reporting of suspicious and unusual transactions, which if it involves an element of corruption, is not only reportable under the Financial Intelligence Centre Act, but also in terms of PRECA, the Corruption Act, and then depending on the outcome, it'll have Prevention of Organised Crime Act consequences. And I wish they can wrap that up so that you don't have the compliance burden, particularly for the financial sector, of having to comply with all these things. Stephen, what are the 8 steps that FATF said we need to comply with to get off the grey list? And Maurice, chip in as you wish.
One of the criticisms by the FATF when they did the mirror report is that we don't have enough mutual legal assistance requests coming from South Africa. So we're slow to respond to requests from other jurisdictions, and we don't make enough requests to foreign jurisdictions. So the first one is we've got to demonstrate a sustained increase in these mutual assistance requests. The good news I can share with you from being at the coalface on some of these investigations, we've done a number of crypto matters where they have been cross-border, and we've identified funds going to Cayman Islands, going to the Bahamas and the US. And the FIC, we know, are communicating with their counterparts on some of these types of matters. So that's the first step. Then we've got to improve the supervision of these designated non-financial business professionals, and we've spoken about the various professions, and a lot is happening there, and we've got to demonstrate that there is adequate supervision over those areas. And up to now, I don't think there's been any regulatory supervision of note against the dealers in precious metals and precious stones. And when you look at some of the cases, gold gets shipped to Dubai. There are entities that act as intermediaries. It's a haven for money launderers, and trading in gold and these diamond commodities are huge. So we also seen crypto is a global problem. And so across the globe, you've seen that we've now brought the crypto assets under the jurisdiction of the FSCA. And that was a much needed intervention. And it reminded me just of a program I saw on crypto, and it was the crypto dealers bragging about how easy it is to move money to a relative in a foreign jurisdiction using crypto. And one of these guys explained that they can move, if you want to send your daughter in New York $300, you come to us. You don't have to fill in 20 forms like you will at the banks, and you won't pay fees. That is what do they call it, TradFi charge. It's quick, it's effective, and the daughter will have the money within minutes. And then my own thought that ran through my head was replace the daughter and the father with a drug cartel wanting to move a few billion. The same applies. There's no screening, there was no monitoring, so that was much needed. We've also got to ensure that the competent authorities have access to accurate and up-to-date beneficial ownership information. I shouldn't be commenting on the solution, but we all know the solution. We've all been faced with having to declare beneficial ownership. Those requirements, the Companies Act has been amended. The CIPC is keeping the registers. So we've done a lot of good work on that. And then we've got the law enforcement agencies have to make use of the FIC to a far greater extent than they have in the past. The FIC has access to intelligence. They can access reams of information. They have data analysts in other jurisdictions. The FIC are supporting the FBI and the SFO in the UK, and we need to demonstrate the same. So those are just the first 4. Do you want me to?
No, it's fine. Amor?
Yeah, well, I think, if we think what we need to demonstrate, and it's the theme that we've been discussing the whole afternoon now, is how do we robustly investigate contraventions and criminal activity and have positive outcomes from that, and how do we tackle it head on. And what I was thinking about, just taking into consideration that concept, it's all good and well with the BBS debacle that we get 2 people that plead guilty and it disappears into the nothingness. But then the slow pace of actually addressing everything that we know, from the state capture investigation, everything that's been reported on BBS. We don't see that traction coming through. And that is part of the problem overall that we've got. And, you know, if we think about, you know, amendments, and yes, the amendments are wonderful. I think we were all in our firm utterly shocked the day when we all had to line up to have our fingerprints taken on the accountable institutions and the duties that we under as a law firm. But if we think about the implementation and how we adopt it and how we embrace it, these are all of those efficiency aspects and technical aspects back to why we grey listed that we need to demonstrate and that we have to start focusing on.
Thank you so much. And I think what's not going to persuade the FATF that we have come the mile that they want us to go is the general South African experience that, yes, we see more criminal prosecutions, people being charged with money laundering, corruption, and so on. But that's not good enough. They actually want to know that the NPA is properly resourced to do their work, and that we are tackling the real problem. The fact that has been little movement, Stephen, and correct me if I'm wrong, on the Zondo Commission findings and little movement on issues such as BBS Bank is not great. It's not going to stand us in good stead.
Maybe I should just interject and defend the authorities, because there has been a lot of effort and a lot of work has gone into preparing some of the matters that were amplified at the Zondo Commission. And there are matters that have been recently placed on the court roll. I acknowledge that I gave evidence on the EOH investigation, and Zizi Kodwa was arrested. I was really pleased that he stepped down from his position, only to see him take up a new role in a different party, which I thought was bizarre, because if you step down for an ethical reason that's still there, how can you? Anyway, that's...
Well, that's not the only example. That nothing happened recently.
But there are a multitude of cases being prepared for prosecution. The other great news is the two things that I want to share with everyone here. And the first is that the state is tapping into the private sector, and there is more collaboration than has happened in the past. We are getting a reception. We almost welcomed and embraced when we bring cases to the DPCI. Whereas previously these were hot potatoes and the IO would refuse to register and hand it to someone else. That has changed. And as you indicated, Marilise, they are adding money laundering charges to some of these cases. And some of it is quite draconian, because we just did an investigation into one of the dairy farms in the Western Cape. The FD stole about 25 million, and he laundered the money through his wife's accounts. She's not a financial person. He operated the accounts, but they've joined the wife as an accused and they've charged her with money laundering. I'm hoping it's just I shouldn't be feeling sorry for the wife, but I'm hoping it's just part of a strategy to get him to cooperate and potentially do a plea and sentence agreement with the state. The other important initiative is the Hawks lack the ability to analyze bank statements. Whenever we do investigations, we have to do the cash flow for them. And that only works if there's a client that's going to pay for those services. So what happens to the clients that can't pay? It's not great. And so what has happened is the financial sector has stepped forward, and they've created this center of excellence using SABRIC at the moment, but there's plans to build a digital forensic center of excellence to have digital forensic expertise, because at the moment, the state has less resources than firms like our own. I've got Seppo in my digital forensic team, and he's got a whole team supporting him. And he doesn't have to apply to go and get a hard drive to image something. We do cases where the police ask us, can we please loan them cables? Can our client supply a hard drive because they don't have budget? You know, so I'm grateful, and the financial sector have pumped millions into this initiative, and it's going to address one of the big weaknesses that we're currently suffering with.
Thank you very much. I mean, I absolutely agree with you. Loiso, your thoughts?
Yeah, just to jump into what Stephen had said, just in support of the state, I think in the midterm budget policy last year, 14 billion was allocated by Treasury toward fighting crime, which would obviously include financial crime. And also, I think there was the establishment of the Fusion Center. And that is various law enforcement agencies, so SIU, NPA, Hawks, SARS, all working together with the FIC. And I think to date, there's been just shy of 2 billion in criminal assets that have been recovered. So it's not like nothing is being done, at least on the assets recovery front, I would say. But yeah, relating to criminal prosecutions, maybe it's a bit touch and go, yeah.
Well, I think just from reading the newspaper, if you compare 2009 to 2024, you get the real feel that something is happening. More.
Sure, I'm sorry to be the sad Sally on this panel, but I realize we've, wonderful 2 billion. It's nothing. It's not a drop in the bucket. And what actually annoys me is that we're a beautiful country. We actually always want to be happy in this country, and we always see the positive in something. I'm not criticizing you, young man. I'm criticizing society. And what I'm saying is, it's terrible that it's only 2 billion. It's terrible that we don't have the resources. 14 billion is nothing to invest in building up these skills. And that's why it's so important that the private sector must cooperate. You can't, I started off by now mentioning that cyber crime is something that's close to my heart. So, but if we think about cyber criminals and within government, the skills to actually deal with cyber-related matters, and you need those techie, in-depth techie skills to do it. There are 14 people available to actually tackle this problem. You can't operate in a global economy with global crimes with 14 little people that do not have the hard drives and the tools to analyze. So therefore, if we think back to the financial services sector, everyone always looks at the financial services sector to put forward the skills and the money to address the problem we've got. But then if we come back full circle, the impact on the financial markets is so significant that we then pay the price through our financial institutions to upskill and assist. And yes, I know, business society coming together, and we've got a positive energy behind it, indeed, to help government to get everything back up. But if you, and I know you shouldn't look at past and always refer to that, but if one look back to the OSCE, Office for Serious Economic Offences, decades back, you had prosecutors working with chartered accountants, working with teams within the serious crimes unit. That is where we need to get to. So currently, we've got teams in various big law firms working with the Hawks to draft the charge sheets to actually prosecute the people on the back of, which is good that we're doing that as a business community. And I think, I suppose it's like if the domino starts to fall, we'll see the energy build up. But we do need that energy to build up quicker. And what we now introduce into the whole addressing the financial crimes, we also starting to experience more and more assassinations. So now suddenly, one of these days, we're going to have to put Stephen in a metal cage to make sure he's just always protected.
That's just to make me behave.
Yeah, let alone keep him alive. So, but we need to critically look at us as a society. We've got a tendency in South Africa to adopt new pieces of legislation. We changed RICO, we changed FICO, we formulate guidelines and policies. We are very good at writing things down, We're very poor at implementing it and making it alive and real. And if I look at this room, it's our responsibility, each one of us here, to passionately strive for the betterment of our country, to actually improve it and to make sure that we abide by those rules.
Just to add on what I'm saying is that the ultimate test that we need to pass, especially with law enforcement, is do they have the adequate skill and knowledge to be able to prosecute matters relating to money laundering?
Yeah.
Although there is assistance from private sector, and there is the ultimate test that will be looked at. I mean, there's great work. I agree with Stephen. There's great work. There is SAMLET that has been established similar to JILB. There is, during the COVID, there were cases relating to PPEs that we can demonstrate. But ultimately, because that was one of the key weaknesses, is that your law enforcement agencies lack the necessary money laundering skill and knowledge. And that, I think, I agree with you, Amo, that is the test that we will really need to pass at the end. Yeah.
I mean, it's so important. I'll get to you now. It's so important to emphasize how far the original list of accountable institutions have come, by the lawyers and the state agents. Because we've been on this journey since 2023. 2003. We have certainly seen a shift in regulatory compliance being a grudge spend in those older bodies or accountable institutions, to now where it's a proper analysis of the risk posed to the business for non-compliance. Not only monetary, reputational, sanctions. For those of you who might not know FICA that well, it's a contravention of most sections of FICA. It's a 100 million rand penalty or 30 years imprisonment. It's a severe impact on the business, and it's a good thing that we're seeing a change. But your emphasis on the mentality with which the private sector approaches compliance is absolutely important. Sorry, Stephen.
I just wanted to touch on the fact that there are some changes underway, and Zondo actually made a multitude of brilliant recommendations. If you look at the summary of those recommendations, he advocated procurement reforms in how the state procures, and I was pleased to see just this week there's been an announcement of some key changes to government procurement. The other change is to try and get the to contribute to almost self-regulate, and how they've done that is by implementing one of Judge Zondo's recommendations, that we introduce a new corporate offence for the failure to prevent corrupt activity. And that's an insertion of Section 34A into PRECA, and that forces companies to be able to demonstrate that they've got adequate procedures to prevent corruption. And that piece of legislation was signed into law by our president in April. It is one of the key aspects to try and convince the FATF that we are doing enough. And it's going to force companies to develop these adequate procedures. So they're going to have tone at the top. They're going to have to demonstrate that they've got proportionate procedures. They've got to demonstrate that they're doing the due diligence on business partners, agents and intermediaries. You're going to have to demonstrate that you've done training, that you've done some form of risk assessment to identify where the gaps in your program are. And then you're going to have to demonstrate that you are monitoring the corruption risk. And if you can't do that, you can be subject to enforcement action. And the UK government has used this effectively to impose large fines on corporates out there. And I think it's a big stick that companies need to be aware of. And one of the issues that I have is I've seen to market these new laws more than the government, and government should be creating greater awareness. They should be issuing guidelines. The UK government has been brilliant. They issue comprehensive, when I say comprehensive, brief guidelines explaining exactly what needs to be done. The US tried to copy that, and they issued guidelines when the UK came out with ministerial guidelines of 12 pages to the UK Bribery Act, they copied them and they issued a guideline of 198 pages that was anything but clear. So those are the types of changes that are happening at the moment.
So a great portion of the UK Bribery Act is that you can rely on adequate measures to protect yourself from prosecution. In other words, you show that you've done that risk assessment, you understand your business, you understand where the soft underbelly is insofar as corruption is concerned and money laundering. And the SFO, as Stephen said, has issued a very helpful directive on how adequate procedures can be followed. And it's good for the SFO in the UK, but it's also good for companies operating in the UK. A terrible example is Rolls-Royce. So you don't say anymore it's the Rolls-Royce of this, that, or the other thing. They had a significant monetary fine. And what the companies normally do is they replace the board, senior management, the new broom sweeps clean. Other companies are able to say we had adequate measures in place. Notwithstanding that, something happened. But that adequate measures then serves as a defense to the prosecution. And I'm very happy to see it enter our legislative regime. Lloyd, do you want to take us through just some measures that South Africa's already taken to try and comply with the recommendations of FATF to get us off the grey listing? Particularly the General Laws Amendment Act.
Sure. I think we've touched on a lot of it already. But yeah, the majority of measures taken by South Africa to get off the grey list were legislative interventions. And then I think, as Stephen mentioned, the deadline was February 2023. And so we'd enacted this legislation prior to that, but there wasn't enough time for South Africa to show any substantial implementation of it. So that deadline came, and despite having had this legislation, we were obviously placed on the grey list. So yeah, the General Laws Amendment Act, I think the criticisms of it have already been touched on because, yeah, among other things, it does introduce this concept of beneficial ownership. And if I'm not mistaken, it just kind of cuts through 5 or 6 pieces of legislation and just adds in this definition of beneficial ownership, which is quite problematic. But yeah, there have been some more positive amendments, I guess, to the FICA, FIC Act. The mandate of the FIC has been beefed up. It's allowed now for more effective detection and monitoring. And also the administrative sanctions, I believe, that the FIC is able to give out for non-compliance now have been increased.
That's very helpful. Amor, what about RICA?
If we think about RICA, and there's a massive hole in the whole RICA process.
So, sorry, just to interrupt. It's when you go and get your SIM card.
Yeah.
And they want your they want your documents. That's the act that governs that.
Thank you. So if we think about the RICA obligations that's been placed on financial institutions and on mobile network operators, and I specifically want to focus on the mobile network operators. It's easy if I deal with a net bank because the bank will ask me certain documents to submit it and they're updated and they've got my biometrics and all that is in place, which is good if I look at a financial services sector market participant. But now I look at the mobile network operators. We need SIM cards and they need to distribute SIM cards. So we can't go to Vodacom in Midrand or MTN in Roodepoort to get SIM cards. They need to send it to all little places in this country. What some of the names have changed and we don't know where we're driving to but wherever, the Northern Cape, the Eastern Cape, up Limpopo. And how do they get it there? So they need a system of agents and resellers, and actually in the informal areas need spaza shops to get these SIM cards to the subscribers. Now think about this. They've got significant obligations on them around it from a RICA perspective to know who owns a SIM card. We know if you can't identify who sits behind a SIM, you can't identify a criminal. And all the ugly things we've spoken about from a criminal perspective actually is done on the back of a mobile phone. Now, how on earth do we expect a mobile network operator to know whether someone in a spaza shop is pre-recording SIM cards and sell it to foreign nationals where there's no link in a database to check a passport number of a foreign national, to anything to make sure if it is a real person. Where we've got it with Home Affairs, we can check South African ID documents, and there's a restriction on the number of SIMs, but it's these floating prepaid SIMs in the market that actually becomes a massive problem. And how do you resolve it? Because we can't tell the mobile network operators, please go sit around a table and formulate a solution, because then they're colluding in terms of the Competition Act. Okay, so it becomes a very involved and problematic area. And just before I came here, I was asked a question by a journalist, and his view was, or the minister's view was, that the ITC sector is a very litigious sector. They litigate all the time. And I thought, how do I answer this question? Because they have to litigate against government all the time, because government comes up with the regulator with the most ridiculous legislation that you have to protect your own rights as a market participant in the economy. You can't expect them to sit back. We need to realize, if we write and publish legislation and adopt legislation, what the impact of that is, or the impossibility to comply with that legislation is.
And the cost of compliance.
And the cost of compliance.
I think certainly insofar as other countries are concerned, which are FATF members, they have the advantage when compared to South Africa that your identity card or your driver's license contains all your biometrical information, your home address, your identity number, a picture, a fingerprint. And we don't have that national database. And certainly insofar as RICA is concerned, I think if you implement that system within Home Affairs, RICA will fall by the wayside, or most of its provisions. And similarly, you will decrease the cost of compliance to many enterprises. And frankly, that and the ability to do business has become an integral risk to South African companies and businesses, which they need to take into account in assessing what is their appetite for risk. And we've seen in the telecoms industry how risky behavior attracts huge regulatory fines, but that business is embarked upon, rightly or wrongly, to have the businesses survive and sometimes flourish.
I think, the good position we're in is that compliance now has got a seat at the boardroom table.
Yeah.
So compliance is now sexy. It's not terrible. The corner in the office where no one actually ever goes to. That is a good thing that we've got. Also that we've got, if we think about regulatory compliance, that it's earned its place high up on the risk registry. And that makes it easier for us as lawyers to engage with our clients as well, to realize how do we align with the legislation, make the law work for us, and not push back against the law.
Yes, and I think it's helpful that that us as a panel appreciate the progress that we've made, and that we encourage our clients to all pull in the same direction for the benefit of the country. We've dealt with many of the amendments to FICA, the General Laws Amendment Act. We've dealt with the introduction of Section 34A of the Corruption Act. FENSE, you've dealt with beneficial ownership largely. Lloyd, you want to talk about the high value goods dealers?
Yeah, sure. Yeah, so this is an extension of the accountable institutions by FICA, by the FIC, and it's quite an interesting one. So high value goods dealer is a business that sells single individual items for over 100,000 Rand, at a cost of over 100,000 Rand. The trends indicate that, to no one's surprise, I'm sure that criminals with their illicit proceeds go and buy expensive things. Hence the need for this change. And so high value goods dealers would include things like your car dealers, dealers in precious metals and stones, art dealers, that sort of thing. And I think it's very important for the FIC to clamp down on this because, yeah, the room for exploitation is very clear. So now high value goods dealers obviously have to now register as an accountable institution. They're going to have to put together a risk management and compliance program. Yeah, and I think interestingly, the FIC has said that businesses that sell goods that don't breach that 100,000 Rand threshold, but reasonably expect to do so in future, must also register as an accountable institution. So, I mean, I think this ties in a lot of with what we've been saying is that since we've been grey listed, the FIC has been coming down really hard on everybody, and this is just another example of it. And I think it's particularly interesting for me because you could really be selling anything. I mean, I've got a friend who owns a printing store, and he sells printers that are valued over 100,000 Rand. And he had no idea what I was talking about, you know, and it's to be expected. And I think there's going to be a lot of difficulty. There's going to be a lot of teething in overcoming this, and in terms of getting everybody up to speed. But yeah, I'd be interested to have your thoughts.
So Lisa, I am curious about this discussion with your friend. Legal advice for free. Okay. I think we've covered the responsibilities of accountable institutions, not by following a tick box approach, but by making the implementation of the legal framework, and it's increasingly complex, meaningful in the context of where South Africa is. As I said, I'm a big fan of encouraging our clients and who may not have been accountable institutions, but are now, to get real about FICA compliance and PRECA compliance and POCA compliance. If you look at the risks that they face, it's almost, the sanctions are so severe that it is almost startling that any business would take the risk of non-compliance. Often non-compliance is not deliberate. They just don't get it right in the first round. And so it's a process of constant improvement.
Sorry, may I say something about the poor printer guy?
You can pass the advice on, Roy.
No, I would just think, you know, it's maybe to an extent if we unpack this, there are unintended consequences as well with the 100,000 threshold.
Yes.
Because someone that wants to fund terrorism or launder money is not going to buy a printer. Let's be honest. He's going to buy a Gucci bag or Louis Vuitton bag or a Rolex watch or, you know, something far more exciting than a printer. One would actually imagine, that a printer ought to fall under the category of cash transactions and the reporting of cash transactions rather than reporting a printer. Because he's not going to buy a printer to print money because he's already getting money for free. So the poor printer guy was caught, and that's the burden on doing business if we think about it. But that's just a comment on.
Offensive?
Yeah, Melissa, I mean, you touched on quite an important element that now it should not be about a tick box approach in terms of compliance. If we really want to combat money laundering, it's about understanding how our clients behave. It's about understanding the financial flows. There's an old saying, follow the money.
Follow them.
We need to get back to following the money. Yes, previously, it was about ID and proof of residence. If any of your clients are still doing or seeing AML as ID and proof of residence, we've lost the plot. We've lost it completely. Now it's about understanding the behavior of the client. It's about following the money, because what Zondo or all the other investigations that probably Stephen deals with on a day-to-day basis, the red flags are always there. The gut feeling is always there. But if the clients are just about, I've opened the account, I've got the KYC, then we've lost it. So right now, I think we all need to get to the point where it's about following the money, understanding what these clients are saying to us, what the intention of the business relationship is their profile now according to that. The minute there's a deviation from that, then we need to start raising the red flags. And I think once we adopt that approach in terms of anti-money laundering, then we are on the right track. But if we're still focusing on documentation, we're still far behind. And I hope people in this room, the advice that they give to their clients is that if you're thinking about you're going to take a template from the FIC, which they have, and saying this is how I'm going to do an RMCP, then we need to understand the risk. The kind of business that I'm doing, what are the risks that is associated with it? And make it practical than about just having a document there. That is shelved and we review it again in a year's time. And our board, if you go and ask your board what is your money laundering risk, they go and have to look for a document which they signed off 2 years ago.
That's quite right. I just want you to take us back to basics. There are 3 phases in any money laundering transaction. And for example, the designation of high value goods dealers very precisely demonstrates why they are now an accountable institution. Do you want to just talk about placement, layering and integration?
Every time we do these fraud investigations, there's a form of money laundering that takes place, and there's a whole lot of actors who touch those transactions. And I think we've got a massive role to play, Marlies, in educating our clients. And what I really worry about is the apathy in South Africa. There's a huge amount of even lawyers who don't understand AML, and that needs to be addressed. So as a profession, we've got to get our own house in order, and we've got to dispense advice to the different sectors. And when we look at the traditional, the placement, the layering, we've all seen the movies. And this is how it actually happens. You have these people running businesses that don't generate any profit whatsoever, and it's just a mechanism to move money. We come across this all the time, and we've got to make sure that we fulfill our responsibilities when it comes to reporting, and we take it very seriously. Marlies highlighted the penalties, and we've got to realize that the regulators are looking for soft targets right now. They want to demonstrate enforcement, and what better way to demonstrate than to tackle one of the big financial institutions? I'm not going to touch on the big law firms, but I think educating, and each sector needs to get its own house in order. The state agency board, they've got to regulate their own people, make sure that they educate and train the precious metals and dealers in diamonds. That sector has to also get its house in order. And I think we need more awareness sessions like this. And I'll just share with you one last story. Mauritius got off the grey list in record time. And when we look at the countries on that grey list, we're in terrible company. We don't deserve to be there. We are there with Jamaica, Nigeria, Cameroon, Burkina Faso, South Sudan. And you look at our systems, you look at our controls and governance, we are really first world. And we've got to just wake up and cure these deficiencies.
That's absolutely right. And change the South African mentality, which I referred to earlier, which is if it's not regulated and prohibited, it's permitted.
Yeah.
That's not the case. And as soon as we get that and drive the right agenda into business, I think we will have made massive progress. I am hopeful that we'll get off the grey list this time next year, but certainly from my point of view, and I'd like to hear you on that, before we go to questions, we're going to see a lot more enforcement by the NPA, a lot more prosecutions, and a lot more sanctions and financial sanctions from the FIC and the other supervisory bodies.
There's a new disease out at the moment, and I'm trying to get the medical aids to recognize if we call it compliance stress disorder.
No, I fully agree with you, Mary-Liz, because that's one of the things that the regulators need to demonstrate, because it was a finding on themselves as well,
Yeah.
and the regulators, that the fines that they issue are not persuasive enough. So they need to go with that next round of plenaries. They need to go and demonstrate that they've taken action. So we definitely, I mean, we from the financial sector were worried that, you know, the sanctions are going to start rocketing, but definitely most inspections are on hand. We've seen it when you look at the FIC's annual report. They demonstrate how they've increased the number of inspections. Definitely more of those, definitely more, a lot of sanctions coming through. What we're concerned about is the number of guidances that FIC is starting to issue.
Yeah.
Although if from other regulatory environment it works, in a South African environment, we've seen it doesn't work. Because the more that the guidance that they issue takes away the financial institutions' risk-based approach. They become quite prescriptive. And the 5% threshold on beneficial ownership is a hot topic right now, but it's got big ramifications. So that is what we're expecting to see. In terms of whether we're going to get off the grey list, we still have about 14 of the action items to finalize. So we're hopeful that those will be closed off. Yeah.
So I know I've been criticizing government all afternoon, so I now come up. I realize the guidance notes, and I battle with those often. But I respect the fact that the FIC is trying to give guidance on how to implement and how to take it forward. That one should appreciate from a regulator. They realize the seriousness of the topic, and I respect that they're trying to assist. Again, back to the point, maybe if you've got a broader think tank dealing or vetting guidance notes, criticizing and before they get published, that could add, I think, greater value to the guidance note or eliminate some of the confusion.
Yeah, I think that's right. You all happy for us to go to questions, or did you have?
One last point, we've mentioned a lot about FIC guidance, but the CIPC issued a guidance on compliance program on 1 November 2018. It was guidance 1 of 2018, and I think there are about 2 guidances, not to criticize that, but that sets out what your compliance program should have, and it's very similar to the adequate procedures that I highlighted earlier. If compliance is not a topic at your board meetings, make sure you get it onto the agenda, because that's part of how you demonstrate the tone from the top. There should be quarterly updates to the board. Whenever they're meeting, there must be a compliance section. And hopefully we can get everyone into the compliance mindset.
That's absolutely right. And it's very clear that the FIC and FATF expects the tone from the top and for the board to take ownership of their risk management and compliance program. It's not something you shove under the CEO's door to sign and then you comply with that. Great, shall we go to questions?
Hey, are you circulating the mic or can everyone hear my question? Thank you. Thank you for a very informative presentation. So my question relates to this January 2025 deadline. What happens if we do not get off the grey list at that point? Is there a further sort of punishment for South Africa? Are we going to be given more time?
Well, I don't know about the more time, Stephen, you would know more, but the blacklist is the ultimate to prevent.
We're not going near the blacklist.
But is that an automatic thing if we?
No.
Okay.
I'm happy to take. So normally the January 2025, if we make it and they say, yay, you've implemented all your actions, we still need to demonstrate that they're effective. So they will still come, they will sit at the February plenary to say that they're comfortable, the fact that they're comfortable that those action items have been addressed. Then in around May, June, they will actually do an on-site again to close out. Then they will issue in the July plenary a statement that South Africa is off the grey list. That's if all goes well. If things don't go well, then we still need to report to FATF on each plenary on the updates that we're making on the outstanding action item. So it doesn't automatically go to blacklist, but FATF still works with the country until such time those action items are addressed. If we don't make sufficient progress, they will issue a statement during the plenary that they're not happy with South Africa's progress and that's their recommended step.
Yeah, and we could stay on that grey list for 4, 5 years, 7 years. There's many other countries that have taken years to get off, and our economy suffers in the interim.
Yeah, and that is the average time is between 3 to 5 years on the list. It was Mauritius who came off the list so quickly, and even the UAE managed to get off the list. So we should surely be able to get off the list.
If I may have a quick follow-up question on that, during the Government of National Unity has stated as one of its objectives to attract more foreign investment. Now, for as long as we are on this grey list, what do you believe the impact is going to be on that stated objective?
So remember, I'll go first bit and then please take over. But I said your transaction cost as someone that wants to invest into South Africa, it is immediately higher because you've got a far more intense due diligence to comply or to undertake and comply with, and your risk assessment is immediately how your investments informed by your risk appetite, and that can deter foreign direct investment into South Africa.
I agree completely. It's an impediment. It's not an insurmountable impediment. It will reduce the volume that we're trying to achieve. Just everyone is committed and trying to get us off the grey list.
Just putting it differently, not getting off the grey list doesn't mean getting on the blacklist. And the way that FATF members deal with grey listed countries is very different to the way they deal with blacklisted companies or don't deal with them. And sometimes, more often than not, the approach is simply we don't do business with that country if you're blacklisted.
Yeah. I think just to add to that, I think if you're on the grey list, look, obviously it's perceived as negative, but if you're there, it still means that there's an intention by the country to become compliant with the recommendations. Whereas the blacklist, I think it's North Korea, Iran, and Myanmar. There's no intention to try and comply with that. So I would say, worst case, even we wouldn't fall into the blacklist unless something goes really bad. And then I think to your first question as well, I think in effect would just be the loss of value of the currency. I think that's also how it would be priced in as kind of a consequence. Yeah.
That's right. Any further questions? Okay, I'm gonna take it this way. It's snakes through the audience.
Thanks so much, Marlies. Andrew Keatley-Smith from ENS. I suppose it's a question, but also a general comment, and I would welcome your views on it. I wouldn't say I'm an optimist, wouldn't say I'm a pessimist. I would perhaps say I'm a realist. And the background to this comment is the highlight of my work career for the last 3 months was the lift working in the Germiston police station when I had a meeting on the 8th floor. And to respond to your offender, I don't believe we necessarily have the capabilities. And even if we do, the infrastructure that exists is stifling whatever good work is being done. And from everyone's perspective, very rarely do we have this opportunity with everyone in a room like this, leaders from various law firms. We've seen our forensic practices grow exponentially over the years, obviously because of this need for compliance. And also a major area being private prosecutions. I say private prosecutions, but prosecutions assisted with lawyers. Do you see going forward some sort of opportunity where we can lend assistance in a more public-private partnership manner? And I think we'd be naive to think that that isn't necessary when you look at things such as electricity, water, healthcare in this country. You almost can't function without that sort of support and assistance. But I defer to the panelists.
I mean, there has been effort, like I said, for that public-private partnership, and it's actually one of the things that are recommended through FATF as well, that there needs to be a close working relationship between private sector and private sector, so that there's also sharing of information, which is quite valuable if you want to prosecute financial institutions. We're not police. We don't want to play the role of, but there is intelligence that is there. And we've seen in South Africa, like we said, the establishment of SAMLET, which is a working partnership between the private sector and the public sector, where there's been so much information. The Fusion Center is absolutely a good story of if there's that collaborative work, close relationship that is there, what it can do. So I fully agree that that assistance to the public sector is needed because of the resources that we have, the skills, and not only that, but the intelligence that we hold that can be used to assist them.
Yeah, and I think for complex prosecutions, there are great counsel in South Africa that the state can draw on. And many of you may not be aware, but the day before Marcus Jooste committed suicide, he was summoned to appear and give himself over to the commercial police. And he was advised that Wim Krengrove and some other senior counsel were assisting the state. And I think that's when he decided it was game over. But hopefully that initiative will flow through to many other complex cases, because we know the state just doesn't have the capacity and the expertise. And what should happen is a mentorship development of skills, leaning on these top counsel to help get these successful convictions. I think we're going to see a lot more of that. The NPA also changed some of the rules regarding private funding to allow donations from the private sector to fund some of these initiatives. And I think as we see more enforcement with this new failure to prevent, there are corporates that are going to be subjected to multi-million rand. It's usually dollars that we deal with FCPA, but multi-million rand penalties. And those funds are going to get plowed into CARA, the Criminal Asset Recovery Account, and it will be used to bolster the fight against crime. So I think collaboration is key. And I've just come from a meeting a couple of days ago at one of the parastatals, and there they were calling on the different providers to collaborate with each other, with the entity, as well as multiple bodies like the AFU. You referred multiple times to OSIO, but the body that I loved is the Scorpions, you know, and I'm hoping we get back to prosecutor-driven investigations. And I think all of this is coming. So I'm an optimist. I think we're gonna get off the grey list quickly. I read out some of the neighbours. We don't deserve to be on that list, and it's up to all of us to make a difference.
Yeah, instead of having the Scorpions, we have Jonas Breitenbach and the DA now. A big loss. So there was a question here somewhere. Okay.
Hi, I'm Nirisha Naidu. I don't have a specific question, but basically comments. The financial well-being of any country should be a priority at all times, not just because of grey listing. We have huge problems in government, and like Stephen, I come from a prosecuting background. I've been with government for 19 years. I understand how the NPA works. Speaking of mutual legal assistance, the difficulty I find in requesting assistance from overseas countries cross-border is that we can't find our own criminals in Soweto. So how do we try to get these criminals cross-border? The skills of the prosecutors are at an all-time low. The NPA had a brain drain, basically. I don't think that the senior members in the NPA have the passion to ensure that the prosecutors have what it takes to get the job done. Prosecutors have a discretion, and much of the time, they're not exercising this discretion as they should because they don't have a know-how. They don't have that experience. They don't have they don't have what is necessary to prosecute. To take somebody from university, put them through the initiation program or whatever, and then get them to prosecute is insufficient. You can get people from the private sector to help draft charge sheets, but at the end of the day, who is responsible for the prosecution? If you hear quite senior prosecutors cross-examining, and that's where you're really excited about your court work is, cross-examination shows your skill as a prosecutor. And if you look at the relevance of the questions, the manner of questioning, it is actually shocking. So for me, not being a pessimist or a realist or being negative, the situation as it stands is actually quite dire and scary. Together with the NPA, if you look at the Hawks, there seems from the discussion, it seems like there's heavy reliance being placed on the Hawks. But even police officers employed by the Hawks need to be prompted, and now Defense Counsel, as to how to take a witness statement. What is relevant to go into a witness statement? That is the basics. You have a crime scene. You can't preserve the crime scene. What kind of integrity are you going to have with the evidence? So these are real problems that we do have. And then the employees themselves, they don't have the standard of integrity that we expect in positions of that nature. From the lowest ranking official to the highest ranking official. I've now dealt with the NPA on a level where I make representations and not prosecute. And you can see from the manner in which they deal with representations that they don't want to take the responsibility for a proper decision. And to prosecute without favor, fear, or prejudice doesn't mean I can do whatever I want to. You are still bound by legislation. You are still bound by regulations. So, and that is a problem. Like Stephen spoke about this man's wife also being prosecuted, whether you feel sorry for her or maybe she's not even involved, but that amounts to a malicious prosecution. There are also other, besides serious money laundering, fraud, your normal divorce matters where the acrimony is taken into criminal courts. The prosecutors don't have what it takes to identify what a false claim is based on the evidence. So the resources, speaking of money, the resources that are wasted on these kind of matters could actually be channeled towards what we need in respect of these serious cases. A heavy reliance on the private sector, yes, sharing of information is important. But if you have government and the state wasting resources. And I know of high-profile matters that are in court, which actually shouldn't be in court because the investigations haven't been done properly. So there's no possibility of success or no probability of a successful prosecution. But this matter is going on for years and years, since 2016, and is still on our court rolls. So with the armed correctional services officials that have, because it's high profile, to guard these accused and that kind of thing, is it really worth it? Because it's billions of money, of rands that's been, in my view, being misappropriated. And then when we rely on the private sector, does it not, I'm talking about financially, does it not allow or encourage abuse of public funds? Because you've got to stop that abuse first before you inject more money into the public coffers. So how do you justify spending that much money from the private sector when this kind of corruption still exists?
Sorry, I make a comment, and because I think that's a very bleak picture, but on a different view, in a very small regulator in South Africa. And this could be some solutions that we could possibly think about. And I'm using the regulator because at that stage I was Deputy Commissioner at the Competition Commission. And what happened under the leadership of the then Minister Alec Irwin, we had teams of the FBI come over to South Africa and train the investigators on how to conduct a proper investigation, how to actually conduct a dawn raid, how to collect evidence, how to preserve digital evidence. I'm raising that in a very, and I'm saying it's a very small regulator in the bigger scheme if we think about the National Prosecuting Authority. But if we can tap in on resources and skills of international agencies, it can ignite excitement and passion in our young people and in the NPA. Yeah. And these could potentially be things that we ought to think about, and government should try and explore, and together with the private sector, because success breeds success. And if they constantly operate in the circumstances that you've pictured, one can imagine that the morale is extremely low and there's no passion. I always look at my team and I think we want to be happy. Why do I want us to be happy? Because happy people are passionate people. Sad people are just low energy people and nothing positive happens around them because they attract negative. So this is it's a society for us to discuss and think about how do we build up to be a proud prosecutor, to be proud in what we can do as the Department of Justice. That could be a potential solution.
We've got to recognize that the NPA was completely obliterated during state capture years, and it is going to take a while to recover. And there are pockets of excellence within the NPA. Andrew will tell you it's a lottery when we wait to hear who's going to be the IO on a complex white-collar crime matter, because we can have someone who has zero interest and we have to do everything for them. Or we've got someone like we had on that case that I alluded to with the dairy farm, where we've got a brilliant IO. He's linking our cases to a multitude of other cases that he's managing. What we don't have enough of is these pockets of brilliance and excellence. There have been, just in recent months, there have been delegations from the US training at the FIC. There's a whole lot of new employees. So we are drawing on these overseas bodies. And I remember the Scorpions used to send their officials, and I used to be so jealous. These guys would go to Quantico with the FBI and get trained. And we can initiate those types of initiatives. I think there's major opportunity. It's not all bleak, because when we do these cases, we try and get as much evidence as possible. We try wrap it up with a bow tie So it's an easy case for the prosecutors to take forward. And sometimes they still mess it up. You know, it is a challenge. We need to just go in the broader terms, we've got to dedicate more money to essential services, you know, teachers, doctors, nurses in state facilities, prosecutors. For me, they're rendering a public service, but it is such an unattractive proposition to go work for the state. And so where you have the excellence, many times they get drawn by the private sector. And we've got to find a way to attract the talent again and rebuild these resources. And I'm delighted with the initiative that the financial sector has driven just with this Centre of Excellence, because that's an opportunity to develop people and grow skills in a vitally needed area.
I agree with your contribution, and I can understand the fundamental concern. And I think both of you, Amor and Stephen, have made good points. I suppose where I become despondent is in the following circumstances. My daughter is doing her driver's license on her 18th birthday. So the owner of the driver's license school solicits a bribe from me because he says he's going to spoil her entire birthday. Or you get stopped, or you can see someone get stopped ahead of you, breathalyzed, and they just dig out money from their wallet and pay. And for so long as South Africans have that mentality, I think we face almost existential problems as opposed to problems that we can find a way to solve. And it's about a collective mentality which we need to break. How do you break it? You have great prosecutions. You show to the public that this has been prosecuted. The person's going to jail for 15 years. So it's a bit of a chicken and egg situation. And as our country matures into a post state capture environment, I do think things will improve faster than we feel it is moving at the moment. But another question here.
Thanks. My name is Rodzani. I am in the banking sector. So maybe just to follow up on the partnership between the banks and other accountable institutions, particularly from the way in which we can accelerate compliance with the new AIs, the attorneys and the estate agents. And there was a point around particularly following the money. So from a financial institution perspective, isn't there a way where we can contribute in fast-tracking this compliance from a due diligence perspective? Because as part of our due diligence, if you are banking a law firm, you probably will have to also make sure that they are compliant with various regulations. And one of them will then be registration with FIC. So I just want to find out from the panel if there aren't any conversation with FIC per se to then say, can we also get a level of empowerment where we can, as part of it, I think guidance note 7A is about to come out now, as part of that conversation, to also extend the level of responsibility to some of the AIs out there to fast track compliance on certain requirements. Thanks.
My view on it is quite different from that, but look, I think some financial institutions might follow a similar approach where their client is an AI themselves, they will, like you rightfully say, Rodzani, that they will do a due diligence on them, where they'll either assess their risk, the RMCP, to make sure that it's adequate, that they've registered with the FIC. And if there are concerns, those are highlighted to the AI, because the minute they bank with you, they introduce a level of risk to yourself. So you don't want to be facilitating that money if you're not comfortable that the accountable institution have adequate controls. The slight discomfort with the banks being seen as regulators is that now we take on that responsibility. That is my only discomfort, because we do, in certain instances, we would engage with the AI to say, why don't you sanction screen? Some of the AI, they will say, when you say sanction screen, what is sanction screening? Then you need to explain to them what is sanction screening. And I think financial institutions can play that role, like with casinos, with lawyers, where when they back with them, they do that level of due diligence. But in terms of playing the role of a regulator, that's why I'm slightly not comfortable, because now you're taking on so much burden on yourself that means you also need to do on-site inspections and all that, because right now it's based on a due diligence questionnaire. You take them out, they fill the due diligence questionnaire, it comes back to you, say, I'm not comfortable with this, and you have a discussion. And I think some financial institutions are already doing that. They're playing that role. Yes, so
we are just under half an hour over time, although we did start late. So I'm going to take one more question. It doesn't mean it's not from you, I'm sorry, but please approach us when we have a snack and a drink, and we'll gladly answer your question. You can get us huddled together, or you can approach any one of us. So your question, last question.
Evening, everyone. My name is Dinao Mahaila. The question I have is, what would be, seeing that the UBO compliance has caused such an administrative burden, what would be the impact on meeting the 2025 January deadline if all companies, well, not all companies, but if most of the companies are still not compliant with UBO requirements?
yeah. So I mean, still battling of trying to find a middle ground with our regulator in terms of their guidance, but it's going to be quite an interesting journey. And this journey is not unique to South Africa.
Yeah.
We found that in the EU, they went through a very similar approach, where they even trying, when they implemented their central registry, they had significant challenges, because what the client declares on the central registry is different to what they declare to the accountable institution. So it's going to be a journey. I don't think this is something that can be done over a period of a short period like we had. Right now, what we're going to be able to demonstrate probably to the FATF is that the necessary legislative requirements have been made. That SIPSI has been given the powers to also now start issuing sanctions to people who are not doing their declarations. In terms of alignment of the 5% threshold across the different legislation, it's an ongoing debate, because it's got so much greater ramification for financial institutions, and it's something that is still going to be debated for quite some time.
I do think, just in closing, that with regard to new legislation or the General Laws Amendment Act, South Africa is going to be able to demonstrate the enactment of the legislation, and it is going to be less important that we have achieved 100% compliance in respect of that regulatory requirement. So I think there will be some leeway, unless FATF takes the view that we simply haven't implemented the legislation as they're required, and therefore we stay on the grey list. But we will have made significant progress as a country to get there. It was absolutely fascinating having this debate with you. Please join us for drinks and some snacks, and discuss amongst each other what we have debated tonight. It was lovely.